Ever thought about setting up a revocable living trust, but you're unsure of what process to follow or what pitfalls there might be? Well, you're in the right place. I'm estate planning attorney Mike Smith with Smith Barid LLC, and I'm one half of the Estate Planning Guys. We help individuals like you to navigate the complex world of estate planning with proven strategies. Today, we'll review why it's so important to fund your revocable living trust so that it operates the way that you intend. Now, there are two primary reasons for setting up a revocable living trust. The first one is to avoid probate when you die. So that's the probate process that we all think of that happens when you die if you have a will or if you don't have any estate plan at all. The second reason that you might want to set up a living trust is to avoid probate during your lifetime. So what do I mean by that? Well, if you go through a period of incapacity, so for example, if you have a stroke or you suffer with dementia, you may find yourself in a situation where in order for a loved one to take care of you and your financial affairs, they would need to file a conservatorship or guardianship proceeding in the probate court. Well, a living trust can help us to avoid that circumstance. That's something that's valuable because a guardianship conservatorship proceeding, anything that involves a court, can take untold amounts of time and can cost a lot of money. So if we can avoid that, that seems like a great benefit to me. So if you're interested in learning more about how we help families protect their legacies from probate, predators, and government intrusions, I wrote a free book titled The Ultimate Gift that lays it all out. If you'd like to pick up your free copy of The Ultimate Gift, simply click the link below, give us your address and a credit card for shipping and handling fees, and we'll ship it out to you free of charge. Read The Ultimate Gift so you can learn how to protect your family. So the trust is a bucket, and you put your assets into the bucket. Then if you have a stroke or you suffer the onset of dementia, your successor trustee, the person that you've chosen, will take over the handle of the bucket without having to ask a court for permission or be appointed as a guardian or conservator. They're just going to take over management of the bucket for you, and they're going to manage the assets that you've put in there for your benefit. And if you are able to come back to capacity, if you're restored to capacity, then you can just take the bucket back from them and manage it yourself. But you've got someone in place who doesn't need any permission from a court to step in and manage your affairs for you. So they can take control of things, take care of you without having to go through that court process. Likewise, when you die, if all of your assets are titled into the trust, then the successor trustee just takes that handle to the bucket and they distribute the assets out of the bucket, following the instructions that you've left in the trust, all of that without having to go through the probate process. So they don't have to go talk to a judge. They don't have to spend months and months waiting on things to be published in the newspaper. It's not a public proceeding like a probate is. They just take over the handle to the bucket. They follow the instructions that you've left and they distribute the assets out of it just as you've directed. So that all sounds great. So what are the possible drawbacks to that? People ask me. They say, Mike, I'd love to have a living trust. It sounds like a great thing. It does all these wonderful things for me and my family, but what are the drawbacks? Why should I, tell me why I would avoid that. Why doesn't everybody have one? Well, the problem for people sometimes is that they don't put their assets into the trust. So they forget to follow through with funding the trust. Putting the assets in the trust is what we call funding. For any titled asset that you have, so for example, a bank account, or let's say that you own some real estate, or maybe you've got R2D2, in order to get that into the bucket, there's a process that you have to follow. So it may mean that you have to go talk with the bank and fill out some paperwork, or if you have real estate, it may mean that you have to sign a deed to transfer the property into the trust. Or in the case of R2D2, you may have a certificate of title and you got to go to the robots department and have that transferred over into the trust. But there's a process that has to be followed to fund the trust. So any titled assets that you have need to be funded in the trust. There are a couple of exceptions. In Georgia, if you own a motor vehicle, those are very easy to transfer after someone has passed away without having to go through probate. So we don't typically put those in the trust unless they're very valuable, collectible cars. And in that case, we may want to put them into the trust. The biggest mistake that people make is after they have 2 or 3 meetings with an attorney, they invest a bunch of time and money into this process of creating the trust, then they fail to fund the trust. And so what happens? Well, if you have a trust that's unfunded, if your assets are not in the trust, then when you pass away, your estate is most likely going to have to go through a probate. And that's the whole purpose in setting up the trust in the first place, right? I mean, as I said, there are two primary benefits to it. One is to avoid probate during your lifetime, so a guardianship or conservatorship proceeding. And the second primary reason for setting up a trust is to avoid probate when you die. So if we don't put the assets into the trust, if we don't put R2D2 into the trust, then we're going to have to go through a probate process to get R2D2 transferred out of your estate into your beneficiaries. That process can take, who knows how long. Sometimes it's really quick, but oftentimes things get bogged down and it can take a really long time to get things through probate to just do what you wanted to do in the first place, which is distribute those assets out to your beneficiaries. Now, when we think about assets that are owned by someone when they die, we got two types of assets. We have probate assets and we have non-probate assets. So anything that has a title to it, so think of, exception for cars, but think of your real estate, think of bank accounts. I would say those are titled assets. Anything like that, if we don't have a trust in place or it doesn't have a beneficiary, so things like 401ks and insurance policies have beneficiaries on them, and those don't have to go through probate. But anything that's a titled asset, so let's just be specific and say your house, for example, that's going to go through probate if you don't have a trust or you didn't transfer that asset into the trust, so you didn't fund the trust properly. So that's the single biggest mistake that I see people make when they set up a revocable living trust, is they fail to fund the trust. They fail to transfer the assets into the trust. It's super important. We always stress that to clients. I know most estate planning attorneys, when they meet with clients, they stress to clients how important that funding piece is. We give our clients written instructions on how to fund assets into the trust, and we're available to help them if they run into issues with transferring the assets into the trust, funding the trust. So as we've discussed, funding a revocable trust can be a minefield and it's easy to make costly mistakes. That's where we come in. Smith Barid provides comprehensive estate planning. We've been doing this for a long time. We guide you through the process of ensuring that your assets are protected and your future is secured, so that if something happens to you, if you suffer with incapacity or when you pass away, there's no legal hassles for your family. We want them to be able to focus on taking care of each other, dealing with the emotional aspects of losing someone, rather than having to deal with a bunch of legal hassles. And that's what we do. So if you're interested in our help, click the link in the description below to schedule a free initial consultation. And remember, planning for the future shouldn't be a chore. It should be a comfort. We're here to make it that. So whether you decide to reach out or not, we aim to provide you with valuable insights. So stay tuned for more videos like this one. Until then, see you in the next video, and don't forget to plan wisely.